Welcome to the program. My name is Marty Shenkman. I'm joined by my friend and colleague, Alan Gassman, who's enjoying the warm weather in Florida, which I'm not doing in New York. It's like 22 degrees out, Alan. So we've talked about for a while about doing a regular monthly program that's not really formatted or a specific topic, just to talk about practical or interesting issues that we see come up in practice. And we were pondering what to call this monthly estate planning magazine or whatever. So we're going to make a request to all of you. Email us and give us a suggestion what we should call this. The idea is to just be informal, but really practical and talk about things that are coming up in practice that we see. And one of the things, just to kick it off, Alan, you have, did I do that? I didn't mean to do that. You have some very intriguing ideas on basis planning and maximizing basis, because that's certainly a hot item. And why don't you walk us through these slides and I'll occasionally interrupt with questions or comments.
Sure, Marty. Well, this, like so many good ideas, comes from an actual client situation. And you just never know what's going to happen when you have a meeting with a client. This client has an irrevocable trust for descendants on the top left-hand side that we put on primarily for creditor protection purposes. We wanted him to have a multiple member LLC to own a lot of his assets, and he's got a revocable trust. And his family came to me and said, "Hey, we've got a problem with all these Nvidia and other stock progress in the market. We think he's well over 15 million now." And that was a nice surprise. And also, he's the beneficiary of the credit shelter trust that his wife left him. And there's really low basis stuff in there. We installed a power of appointment to get a higher basis on his death. But now we're realizing that's not going to work because his net worth is up to 15 million. What is it that we can do? Should be worried about it? So the first thing I thought about was the credit shelter trust. And with a credit shelter trust having about 5 million of appreciated assets, how do you get as much step up as possible on his death using as little of his exemption as possible? Right now, it says that on my death, on the death of the grantor, I'm sorry, on the death of my husband, he'll have a general power of appointment, but not to the extent that would cause estate tax on his death. So there were also some aspects of that credit shelter trust that I wanted to improve. It goes outright on death, and it's not in an asset protection trust state, so there's exception creditors involved. So on the far right, we're forming a Section 678 trust. The trust is going to be pretty much for the same beneficiaries, but it's going to have better features. It's going to be in an asset protection trust jurisdiction. And we're going to fund it with $1 million from the credit shelter trust and a decanting. And the credit shelter trust is going to owe it $3 million.
Alan,
Yes.
are you saying that the new 678 trust is going to be grantor as to the credit shelter?
Yes.
And what mechanism do you use? What rights do you give the trustee of the credit shelter to make the new 678 trust grantor as to it?
It has the power to withdraw all income, all
So
kinds of income, which has to include ordinary income, capital
capital
gains
gains.
income, etc.
Yeah, there's some different views, and I don't know that we need to get into it. Some people believe that works perfectly correctly and will be 100% grantor as to the credit shelter trust. And some believe you need to have a right to withdraw principal as well. And I think there's some dispute on that.
Right, because the statute says income or principal.
Right.
Right. But in
So,
any event, so the credit shelter trust is going to set up an LLC. It's that LLC that's going to owe $3 million to the 678 trust. The credit shelter trust is going to keep its most appreciated 4 million worth of assets and put it under that LLC. So now that LLC will have a net worth of $1 million, but it will contain $4 million worth of appreciated assets. When the client dies with the power of appointment, we only need $1 million to get a full step up on the 4 million, the way that this is leveraged.
I'm sorry if I wasn't following. Can you explain how you created the note? What gave rise to the note?
We just created a note. We just had the LL we had the credit shelter trust put $4 million of investments into the LLC, and we had the $3 million note come back to the credit shelter trust. And then in the decanting, the credit shelter trust transferred the note, the right to be repaid on the note, to the Section 678 trust.
So the note was really created contemporaneously with the transfer of the 4 million of assets. So it's almost like it was a net transfer from the credit shelter to the LLC of 1 million.
That's right. That's right. So the net result is the power of appointment is over the LLC, and the step up, when you read the Tufts case and the other literature, the step up will be to all the assets in the LLC as long as the power of appointment is over the entire LLC, to the extent of its net value, not its gross value.
So you're saying you get a step up of 1 million or on the full 4 million?
Full 4 million. I'm only using $1 million of exemption,
Right.
but I get a step up on the full 4 million.
Okay.
So then I've got to keep the rest of his estate down below 14 million. And on the left-hand side, I've got his revocable trust. And under his revocable trust, what I had when I started was what you see here as Smith Family Holdings LLC, owned partly by the revocable trust, partly by this irrevocable trust for his descendants. It's really owned 97% by the revocable trust. It's owned 3% by the descendants trust, but it has equal voting rights to the descendants trust. So on the client's death, you can take a discount. If you wanted a larger discount, you could give all of the voting rights to the irrevocable trust. So, the client said, what kind of a discount will it be? And I said, hopefully it will be a discount of enough to get you to below the 14 million. As a practical matter, you may interview 2 or 3 different valuation experts to see what their opinions are after death as to what that discount would be. And he said, well, we have some assets that we would intend to sell right after his death. And we'd like to get a full basis step up on those. And then we have other assets that we plan to keep a long time. So it's not that important. We would want to have those receive a discount. So that's
Alan,
right.
just let me interject a comment. That's a really important point you made that's not technical, but I so often see it overlooked. Some people in their zealousness to get basis step up start doing planning without first confirming with the client which assets may have a long-term holding period. And it's not uncommon for a family business or that family cottage or vacation home to be, they'll assume that they're going to hold it indefinitely. So, getting a basis step up for an asset that may not be sold forever doesn't really accomplish much.
Right. Right. So we set up what I call the new low or no discount LLC, and it's owned 99% voting by his revocable trust, 1% non-voting by the trust for the descendants. And that LLC is going to receive the assets that he wants the highest step up for. And maybe those will be leveraged. Maybe that'll be an apartment complex worth 3 million subject to a $2.9 million mortgage. So now I'm working with this client. Fortunately, he's very sophisticated to decide what goes in each basket. And then when you see the pink non-grantor trust for children, he said, well, what about an asset that is way upside down, but we don't want to sell it anytime soon? How do we preserve the capital loss? I don't want to get a step down in basis. So he could make a gift of those assets to a non-grantor trust for his children to use up part of his exemption to preserve that high basis. And then after his death, other assets could be added to that trust that have a low basis, and the sale of the asset with the high basis could be used to offset the low basis assets. So this is going to save this family quite a bit of income tax after the death of the patriarch of the family.
That's another really important point that often gets overlooked. There's almost this assumption we don't even call it a basis adjustment at death. We call it a step up. That's like the common phraseology, and it's not. It's a basis adjustment to fair value. So stripping out and safeguarding the losses could be very important, and that's often overlooked as well.
Yeah. So I don't really have a name for this. Maybe we'll call it the optimized basis system, OBS, or something like that.
Oh, you got to have an acronym and a name, of course.
Right. Right. Now, if you want to go to the second page, I think we found a little opportunity here. And that is when you have a variable annuity or a life insurance contract, you don't really have basis. You have what's called uh, the cost of the contract. So if I were to put a variable annuity contract that cost $1 million under an LLC, and then on the death of the client, that LLC, because of voting rights, may only be worth 800,000. The fact that the LLC has a basis of 800,000 does not cause there to be gain when the annuity is liquidated as to the $100,000 cost. I mean, as to the $1 million cost. So I think using an annuity, a variable annuity or a deferred annuity, you may be able to get your estate tax discount without a basis step down. And with a variable annuity, you also have the income tax advantage of deferral of income tax. Although when the income comes out, it comes out as ordinary income. And I'm not always a big fan of annuities because of the significant cost that can be incurred, sales charges, surrender charges. But there are annuity contracts on the market that are very competitive. So this may be something else worth considering.
Alan, just curious, you have 1% voting in your examples. I've seen some people use 1%, some people like more than 1%. Um, what about 1/10 of 1%? I've seen that used too. Any thoughts on what amount you really need? And the 1/10 of 1% I've seen commonly where you're doing the Powell Moore planning and stripping off a special voting membership interest that another trust will buy so that the client doesn't own or can't control in conjunction with others the right to liquidation or distribution. And any thoughts on the percentage used?
I think the main thing is that the client dies without any voting rights. I don't think it matters if it's 100th of a percent or 1%. I think 1% is, what's most commonly used. You may have an auditor scratch their head and look at something closer if it's less than 1%. Um, and, I'm not illustrating the strangy special voting powers and things like that there. But I've often seen 1% used. I've sometimes seen 1/10 of a percent used.
I've seen people get very zealous about their view of what has to be done, but it's different folks, different strokes, just like with some of the other stuff we talked about. Should we go on? We'll tackle another topic, or you have anything more on basis?
No, let's go.
Okay. So let me bring up a new topic that wasn't on our proposed agenda, and we'll just talk about it briefly. I had an interesting question. So a client has a non-grantor trust. um, a the major holding, almost the entirety of the trust assets went belly up, worthless, and he wants to get that loss onto his personal return. So, any thoughts on how you do that? Should I just make some comments? Maybe you can respond to what I say.
Yeah. Yeah. You got
So we have a non-grantor trust. It's got what the client says is a worthless security, and he wants to terminate, or the suggestion was made by the accountant to terminate the trust so that the loss would pass through to the beneficiary, and the beneficiary could report the loss on their personal return because it's the final year of the trust if you terminate it. So I started pondering it, and it was kind of interesting. The first question, which I'm not sure anyone's addressed, do we know that it meets the criteria for a tax loss as worthless? The tax law has some pretty stringent rules on what is worthless. And the fact that it's just a bummer doesn't make it worthless. I was actually surprised. One of the things, and I didn't really get a chance to research it, but one of the things that I had looked at said that even if the company is in bankruptcy, it's not a guarantee that it will qualify as a worthless security because it may come out of bankruptcy. So the threshold issue, is it really worthless, hadn't been looked at, and that's something worth considering. Another question that I ponder, most of the trusts, maybe even almost all the trusts other than marital trusts that we create, tend to be fully discretionary sprinkle or pot trusts because it gives us more flexibility to get money where we want. It gives us more flexibility to shift through the DNI deduction income to somebody in a state without income tax or in a lower bracket of income tax. So if you have, and Alan, I have no answer to this, but if you have a fully discretionary sprinkle trust with an independent trustee, say, and that independent trustee can sprinkle money anywhere, if in fact there's a loss from a worthless security, how does that get allocated? Any idea at all?
I don't know. I don't
It's
know.
an interesting issue. I've never seen it in all my years of practice. I don't know that you can just pick. Maybe you can, but I don't know that you can just pick which person gets it. Perhaps, it has to be pro rata per beneficiary. I don't know, but I thought it was an interesting question. Um, Another thing that came up, the client asked the trustee, how do they terminate the trust? Do you know why the client reached out to the trustee, Alan? Of course you do, because I would bill them for the advice. The trustee just told them. So the trustee's answer was, well, we'll authorize the distribution of the remaining assets that have some value, and we'll resign as a trustee. So now you have a trust with no trustee and no assets, assuming, which no one has gotten into, whether the security is worthless. But I'd be concerned if you want that loss to pass through, what do the tax laws require for a trust to be terminated? I'd be curious to first look at the trust and see what the trust requires for termination. Is there a clause that lets you terminate it for being uneconomic or too small? And does that even apply? What does state law provide for? Again, I've never seen this issue, and we're still pondering them all. But the question is, if you merely have the trustee resign and you distribute the cash, is that enough to terminate a trust so that the loss, in fact, passes through? So, another interesting issue, another thought. Um, Non-grantor trusts are talked about all the time. They're not so easy to operate and administer to make sure that you preserve your non-grantor trust status. If you inadvertently make a loan to the settlor, is there adequate security? Is there adequate interest? I mean, it's very easy to trip up and do one of a whole bunch of things. A spouse is a beneficiary, so it's a slant, spousal lifetime access non-grantor trust. Did the adverse party approve the distribution? Just because the kid says they approved it, how do you document that? Is the kid even an adverse party? There's some old case law, and I think we talked about this on a prior webinar, last, a month or so ago, that, if the settlor or the trust controls a large estate and the beneficiary knows they better do whatever the settlor, let's say mom, says to do, is that really being adverse if they just acknowledge and do whatever they're asked to do? So there's a whole bunch of questions. But if they failed the non-grantor trust status, which was desired when the plan was formulated, may we now argue that the trust is a grantor trust and the loss just passes through and maybe avoid all the other issues?
That's a great idea. I like that one best.
And clients seem to be loath to come back and let us administer trust. So, you know, it may very well be they violated it. The other question, but I'd be a little more concerned, especially if it's intentional and nominal and near the time of the termination of the loss. Can you intentionally just make that loan to the settler and argue it's become a grantor trust? So it sounded on first blush like so many things that we do to be a very simple little quickie answer an issue. But it's like an onion, like so many things. Each time you peel off a layer, you see something more and something else. Um, Ready for another topic, Alan?
Sure.
So this is one I really don't want to talk about. Tell us, what's the status of the Corporate Transparency Act? You don't want to talk about it either. It's like that horror movie. We're back. Maybe.
Well, fortunately, it was killed by the Treasury Department when they decided that no one has to report except a foreign company registered to do business in the United States that's owned by foreigners. Otherwise, the fact that the 11th Circuit Court of Appeal decided that the law is constitutional doesn't really mean anything from a practical standpoint to any client that I'm aware of. Because I can't even think of a client that has a foreign company that's registered to do business in the United States.
And I would really doubt that under the current administration, they're going to use this court case to resurrect this really incredibly bad act. The
Yeah,
piece that I just don't understand is if they wanted reporting, why didn't they just come up with a simple IRS form that gets appended to every tax return, let the accountants fill it out, make the reporting at least reasonable, which it wasn't. It was impossible to understand. And they could have gotten probably a large percentage of the information they wanted without any real burden, but it was like so over the top. So I guess we can tell everyone that it's now been held constitutional, but hopefully it doesn't matter and hopefully it'll never matter.
that's right.
Now,
That's
I don't know if any other states have followed suit, but New York has an LLC reporting statute similar to the Corporate Transparency Act. Um, my understanding, and it was nuanced, so I may be wrong, but my understanding is it takes effect January 1 next year. But based on the limitation that you just explained, that it only applies to foreign individuals, I think, doing business in the US with an entity. And it only in New York applies to LLCs, not corporations, which is kind of odd. I don't understand that either. It makes no sense. But it seems that in the current iteration, it should only apply to the foreign reporting aspects of the CTA that the federal law applies to. But it's not fully clear, and I'm not sure what might happen with that legislation. I'm not aware of any other states that have followed New York's lead. I don't know why New York is doing it, but hopefully that will not amount to anything for New York or elsewhere. Um, Alan, one of the things that we were talking about, and I think is difficult conversation for us with clients and difficult even for a lot of practitioners, is the this Right to Die Act. Some call it assisted suicide, and I believe it kind of reminds me of the old DAPT laws, where it started, I think, in the U.S. with Oregon. And we now have, I think, a dozen states approximately that have adopted such legislation. One of the states, and I forgot which, doesn't have legislation but had case law that permitted it. But it's in about a dozen states, and New York, I think, is about poised to perhaps imminently have the governor sign legislation that was passed uh, and permit this right to die in New York. Can you talk about that for a minute? And then I have a checklist of ideas that we can discuss after your introduction.
Yeah, about 6 weeks ago, I had a meeting with a client and her children, and the client got a bad diagnosis, and it was a kind of cancer that is not pleasant to die from. And I said, you could go to Oregon and get a suicide pill. And the client said, I'll think about that. And the children said, yeah, we could think about that. And the death process happened much faster for the client than any of us expected. And after she died, her children came to me and said, I sure wish we had gone to Oregon because that was just candidly a gruesome experience for us and for her. So I think the fact that a state like New York, which is highly populated and sophisticated, is now bringing this opportunity to its citizens, residents, says to the rest of us, we need to make sure that our clients know about the opportunity. And you don't have to reside in Oregon to go there with a prognosis that can permit you to get hold of a suicide pill that has to be prescribed and administered, self-administered. So you can't wait until, sorry, I don't feel good, I feel terrible, I can't use my hands. Well, then you can't take the suicide pill. It's just, it's a horrific situation that a lot of families face, and there's an alternative here. I thought it was very interesting, the New York statute. First, it was going to allow tourism, but then the governor said, I'm not signing it unless you guys change it. She hasn't signed it yet as of today. She plans to sign it in January. But it prevents,
Alan, can you
go ahead.
define what you mean by tourism?
You have to be a resident of New York in order to take advantage of the statute once it's passed. So you couldn't be a Floridian who just says, "Well, I'll go visit New York for the purpose of getting my prescription for a suicide pill and being able to have my family help me take it without being accessories to homicide." So that's what
One
I'm trying to.
one of the issues that we were looking into with this article that we have in process on this is how do they define resident for purposes of taking advantage of the right to die or assisted suicide law? My understanding, and I have to parse the language more carefully, but maybe you have some insight. If not, it's certainly something we're going to look into, is that you have to be in the state for 6 months, but residency is defined a little differently. So it may be possible, I think, to meet the requirements for the right to die statute, but not necessarily become subject to New York income tax. And this is not only New York, folks, because like we said, there's about a dozen states that have similar legislate law, and I think there's a large number of states considering it as well right now.
Yeah, I did not look at threading the needle for tax purposes.
Yeah, I would hope that they don't seek to do that because what a tragedy. Somebody is facing such horrific, just tragic, heart-wrenching personal decisions and not have to be taxed in order to do this. I hope that's not the case. We'll try to parse that and maybe we can address it in a future program. Um, I have a quick checklist that'll summarize some of the things you've said, maybe add a few more. I'll just run through quickly. And this is not based on the New York statute. It's just sort of generic from many of the different statutes. And I think conceptually, keep in mind that what the states are trying to do is the consequences of this are so significant and obviously difficult that and controversial that they want to make sure that there are I don't know if hurdles is the right word, but safety measures that one has to pass through in order to take advantage of this. So you have to confirm the jurisdiction and legal status of the individual. There's an eligibility screening, which includes age and residency that we've talked about. Often there's a first verbal request to attending physicians. There has to be a certification by the attending physician. And by the way, one of the things that concerns me about that is if you're in a state that doesn't permit this and you want to establish, and let's just say meet the time criteria to take advantage in a different jurisdiction, you have to get all new physicians. This is not easy to do. And that's going to be quite an impediment. And not every physician is going to be comfortable doing this. And we even have to talk about advisors and attorneys that may not be comfortable. So you have to get a certification from the physician. You have to have sufficient mental capacity. That can be an issue with a lot of the very debilitating diseases. It's got to be an informed decision. The physician has to counsel you on feasible alternatives. You have to make a written request that has to be witnessed, and obviously by independent witnesses, not an heir. That's not going to work. There's a waiting period. They want to make sure it's not ill thought out or not thought out. And then there may have to be another request. The prescription has to be issued and verified. The prescription has to be filled. There's a final attestation in some jurisdictions. The death certificate and documentation has to be addressed. So even once all these hurdles are met, there's still other issues that may have to be addressed. So it's going to require legal counsel. And because this is in so few states and still fairly limited, and even the numbers of people that have taken advantage of this, even Oregon, which was I think in the 1990s, is still a fairly small number. A lot of this stuff is going to be new for anyone touching it. You have to dispose of safely whatever medications were not used. That's really important. God forbid somebody else gets a hold of it. You have to deal with perhaps the policies of the physicians and the institutions they work for. Insurance contracts in New York law. I don't know if you mentioned that the New York law provides that it's not deemed suicide, but that doesn't mean there may not be an issue. And if there's a technicality, they may argue it. Um, Communications with family is probably one of the most difficult aspects of this. So one of the things that's important is this really has to be addressed from all the things we've talked about in advance because it's not going to happen otherwise. And one of the issues that creates is many advisors, attorneys, and other advisors are not going to be comfortable from a moral perspective or their own religious observances or beliefs in involving themselves with this. But I think, and Alan, please comment, I think our responsibility as advisors and certainly as lawyers is we have to zealously represent and help the client. So if a client wants this, I think we have the obligation to say to the client, even if we're morally against this option exists. And if you're not comfortable doing it or ethically or morally feel it's wrong, then you have to say, listen, here's an option that exists of assisted suicide. Um, if you are interested in pursuing this, I can't do it, but you need to get somebody else to help you immediately because time may very well be of the essence. And I'm sure a number of people are going to struggle with that. Alan, any thoughts or comments?
No, I agree with you completely. And this goes with something else that we face in our estate planning practices. So when clients tell you that they have a serious illness, you've got to move on that quickly because you don't want somebody dying in the middle of an estate plan and they're going to go through terrible emotional turmoil sometimes, which is going to cause them not to be able to be a good estate planning subject. So as soon as you find out a client has a challenging condition, you need to do your best to get them in the office or on a Zoom call and talk about these things and cut right to the chase. And what I say is, Floyd, I'm like 1 in 3 on average. I've got about a 33% chance that a client like you is actually going to finish an estate plan after getting a diagnosis like that. Can you work with me and make this a high priority? And
It's what you
you've
say
got
is
to,
very true, Alan. It's very hard emotionally for people to do. And often what they don't realize, however difficult it is with everything else they have going on, the family, the heirs, the loved ones they leave behind struggle with the mess that's often left.
right. So, Floyd, it may not be perfect, but in the next week, can we put something together that you can sign? So then you'll have more time to think about it and focus. But heaven forbid we lose you faster than we expect to. We've got something in place. That's the type of conversation which can also be, and by the way, have you thought about what the end is going to look like? Would you like to consider going to Oregon so that the end can be much more humane for you and your family, if that seems to be something that you're interested in?
I think the health proxy, the living will, all these things need to be updated. I find frequently that clients will make one type of decision when this is theoretical, right? They're well, they feel good, there's no issues. Then if they lose a loved one close to them or they themselves become very sick, their perspective on what they want may change. And I think it's really important for all the advisors. If the client, if an advisor, the financial advisor, the insurance consultant, the accountant become aware that this kind of circumstance even may be occurring, you need to demand that the client go to their attorney right away. I don't think I generally use such forceful language, but they need to get stuff updated. It's not a time for different people to try to be the quarterback or deal with it. They need to get their legal documents reviewed and, if necessary, if possible, updated, like Alan said, as quickly as possible. And so long as they have capacity, if they change their mind or refine what their plan is, we can do it again. But I agree 100% with Alan. You want to get something in place. And honestly, even if they have stuff that's 10, 15, 20 years old, even if it kind of does what they want, it's not going to. Our drafting techniques, the sophistication of the trust that we create for even modest estates is just so much more robust than it used to be. And you don't want documents that are, and I'm curious if you've encountered the term stale. You got a 15-year-old healthcare proxy. You know, the people using it, is this still valid? Let me make sure it's still correct. It's so old. You don't want someone going through that.
Yeah.
So let's change gears again. And I don't know that we're going to get that detailed on this, but just something else that I just had come up. Um, uh, Post-death events that impact valuation as of the date of death. And I think there was a case called Noble where the court looked at post-death events and said, listen, these post-death events, even though they occurred after the decedent passed, will affect the value because they kind of indicate the actual value. But the Jackson estate, Michael Jackson, on his death, um, although there was a large adjustment upwards in the value of his rights, music rights, other intangible assets, because of reputational issues, they were valued at dramatically less than what the IRS argued they were worth. But nonetheless, it seems that as time went on after he passed, that those large valuations actually were realized because despite the reputational issues, the value grew tremendously. So, you know, that may well change the analysis or certainly make it more uh, intricate and varied than the prior law under like the Noble case. So it's very important to evaluate post-death events, and I would think probably disclose them and explain why they're not relevant. But that remains an interesting issue that could have a substantial impact on an estate. Um, One of the things, uh, um, Alan, any thoughts or comments on that?
No, I think you've explained it well.
Yeah, I think it's very fact sensitive. So I think you have to be very careful drawing a conclusion based on the case law. We obviously want to look at the different cases and see the analysis and what was discussed, but I think it's very important to try to document and get the facts corroborated that support whatever value is being used. And again, I haven't seen a alternate valuation date on an estate in a while because asset values seemingly have gone up so much. And I didn't seem to get that issue like during COVID when there was a temporary dip. But, you know, things cycle. We're going to all see that again. So there's always intriguing valuation issues. And we have no idea what the level of the exemption is going to be in the future. You know, it's right now $15 million permanent, but who knows? Um, Alan, why don't we, just because I'm always seeing new things and learning new things and experimenting in new ways, let's just, and this may be a regular thing we talk about because we're always coming up with new ideas. We've talked about background checks. We did a whole webinar on using AI for background checks. If you are not, as an attorney, accountant, insurance consultant, what a financial advisor, in any of the allied professions, if you're not using, even if you're a client, if you're not using AI background checks to evaluate people you're doing business with, to evaluate your own situation before a large wealth transfer, you really should be. And we just posted a whole webinar on that, which I thought was fascinating. Alan, any other comments or thoughts how you're using AI or seeing it being used?
I think more and more people are using AI to review documents and to even look at letters that you are about to send to a client just to see what you're missing. AI is so valuable as far as providing checklists, and it will give you 15 items to think about, and maybe only four of them are important, but two of those four you may not have thought about. So using it just to check documents, just to check things that you're doing, I think is very valuable.
Let me just interject. That to me, what you just said is there's inherent in what you just said a really important point. You have the discretion to see if I got the numbers right, that there are four things you may have missed, and two of them may be relevant or whatever. But clients who don't have the expertise to evaluate what's relevant and what's not are going to get themselves in trouble. Advisors who don't have the expertise could really do harm to themselves or their clients. So I know a lot of financial advisors are using all these AI platforms to review documents. I think it's wonderful because it's clearly a lot to start a conversation with, and you can have just from the AI output a very intelligent and value added conversation with a client. But you need to be careful how far you go. And if your actual expertise is limited, keep in mind what Alan just said, because you don't want to start arguing with a person who has real expertise in this because you don't know where the AI is drawing its ideas from or its conclusions from. And if you got 15 ideas out of AI and four were really valuable, maybe the others aren't, and two may be really home runs, but you got to be careful because the rest of them may be problematic or not relevant. So it's a great tool, but it has to be used in the right way by the right person. One of the things, and I actually just did this experiment the other day, initially, I was not comfortable with the output having a transcript created from a client meeting and then having AI draft a summary memo. What I've learned is not, about training the AI. Why don't you define that and then I'll tell you what I did.
Well, we give the AI in estate view, we give the AI protocols. So we say, if I ask you about a trust, make sure you analyze the following 16 things in this order.
So I'm
And
going to give you a different spin, Alan. So maybe this will be intriguing to you. It wasn't really so much about training the AI only, because I have a list of criteria I give AI when I wanted to extract from a transcript a memo to a client following up on a meeting. I also had to train me, and that hasn't been talked about. What I learned is if I'm a more conscious, and it's fascinating as you do it and get better at it, if I'm conscious about how I say certain things, if I'll say things in the meeting like, this is a critical summary point that has to be in the summary notes of this meeting. The client doesn't even know or notice that I'm saying that, but the AI notices. So when you finish making a really important point, you can emphasize it, you can repeat it. If you have a discussion that really shouldn't belong in the summary, I don't think this should not be what we just discussed is really tangential and should not be included in the summary of the meeting. I find clients don't even get disturbed or notice that I'm saying that. But if I'm more conscious of what I say and what I emphasize, and you use the training of the AI, it's very powerful. I sent for the first time after tinkering with the things we just talked about, a summary of a meeting to a client. Now, I'm not sending anything from AI out of the office without reading it. We've all heard about the horror stories of people quoting, hallucinations that for citations that didn't exist. But I told the client, listen, I don't like the cadence or I don't know what word to use, but the sound of the AI summary. There's something in the tone of the writing that I don't love, and it clearly sounds like AI. And I don't love the formatting, the way it comes out. And I've tried to fix the formatting, but at some point, after some level of fixing it, or with commands or requests, I kind of, it's as far as it can really go. But I said to the client, this took me an hour and 15 minutes to do. Had I not used AI, it would have taken me 2.5 hours. It would have taken me more than double the time. Are you okay with this? And what do you think the client said, Alan, to get a lower bill?
Of course they are.
Of course they are.
Yeah, they got it faster too. They didn't have to wait as long.
So it's really fascinating. I don't know how many of our colleagues are using transcriptions of meetings in AI to draft follow-up meetings. The other piece that was really valuable with that is I could focus on the meeting. I didn't have to focus on writing notes. And I didn't have to have a separate person in the room taking notes because I was concentrating because it was technical. It's really incredible how it's transforming how we can practice in terms of cost and efficiency. What else you want to talk about?
Well, I do want to mention when a meeting is over, your work is not over for that meeting. If you could just spend 5 minutes after the client leaves, preferably for me with a secretary, a short recorded conversation saying, we just had this meeting. They're doing great. I want to make sure I don't forget to A, B, C, and D. I didn't mention it during the meeting, but I'm concerned with Margie's health. She was kind of forgetful during the meeting. And I promised them this and that. They promised me this and that. And I'm sure the AI will emphasize those things. So now I've done a better job of analyzing the meeting than I would have done if I had just walked cold out of the meeting. And AI has a little 5 minute prompt, so it knows what's important. But don't walk out of a meeting and say, I'm done with the meeting because AI is going to do all my work now. It's actually more work to use AI sometimes, but a more thorough result. It's a Bronco you're riding here. It's going to keep us on our toes for the years that come.
But a very powerful Bronco.
Very powerful Bronco.
And I'm finding that just like document generation software, there's a learning curve, but for even the short run, the efficiencies, the better practice is just incredible. Um, we are working on an article on the right to die and assisted suicide that we had just talked about. I was embarrassed, and now I'm going to say it on a recording. So I'm really going to embarrass myself. I couldn't find where I'd saved the article that your colleague had sent me on this, and I was embarrassed, and I didn't want to call you and say, Alan, I can't find the article. I went into Copilot. We use Copilot as one of our AIs, and I use Copilot because we have all of our documents stored in the SharePoint or Microsoft Cloud. So I said, hey, Copilot, there was an article that somebody in Alan's office, because I couldn't remember Jacob's name, sent me that had to do with the New York statute that's proposed on right to die or assisted suicide, because I didn't remember what language New York was used. I can't find it. Can you find it for me? Less than a minute later, I got the summary of not just that, but every article or every memo I'd ever written on the topic with links, and yours was the second one. I clicked on it and bam, there was the article. So, instead of having an admin, listen, I can't find this thing. Go look through all the emails, look through my files, look in the system, do a search in net documents. Bam, it was there. So there's lots of really incredible things, and I think we're all going to start discovering more and more things as time goes on, and it's only getting more and more powerful. Um, One of the things, changing gears, I think we have one last topic, and then we're done. I think so one of the things, and I don't mean to be critical, forgive me, and I'm not trying to badmouth anybody, but we just keep seeing a growing trend of account titles be completely undermining the estate plan. Where clients, we just had two clients pass away, and almost every asset they had unbeknownst to us, after years after they left our office, but they didn't come back for an update because, the classic answer, Alan, everyone gives why they don't come back. Nothing's new, right? Nothing's changed. But the financial firm that they moved to was trying to be helpful. They meant well. So they retitled most of their accounts as POD and TOD and nothing in the revocable trust. So nothing went to the trust for the surviving family. And all the asset protection and tax protection was destroyed. Very important. Don't make assumptions unless you understand the plan, what should be done with title to accounts. It's not a simple matter. And all the advisors should advise clients, you periodically have to get your team to review stuff. And it's not enough just to talk to the lawyer because the financial advisor needs to understand the plan because they can't do it right if they don't know. So really important to keep stressing these annual reviews. And it's sad to see an entire plan undermined. Now, given that we have a higher exemption, my first reaction is, all right, the plan got messed up, but you know what? It's actually better because it's going to be in the estate and it's simple, it works. But then I realized, what if the surviving spouse remarries? All these assets are in his or her name. It could be an unfettered disaster. So even the simple stuff, and Alan, this goes back to kind of a theme of some of the points you made on basis planning. How long is that asset going to be held? If that family vacation home is going to be held forever because everybody loves it and it's got deep, historical meaning for the family, why are you doing basis planning? It's never going to be sold. We can't overlook the simple stuff. Alan and I are like many of you we're tax geeks, we're nerds. I'm sorry, Alan, but I'm saying it about both of us. We love the really hyper technical stuff. I mean, Alan, I've never seen him so excited except when he's talking about GST allocations. I mean, it's just he loves it. But the simple stuff is often even more important, and we can't overlook that. How long is that asset going to be held before we go down a whole path of basis step up? If we're doing all this tax planning, what about the asset protection planning? And Alan pointed that the whole plan he showed us earlier started with asset protection. And too many people, it's off the charts because it's not on radar because they're so focused on taxes. Saving taxes is great, but Alan, as far as I know, the maximum estate tax rate is 40%. Creditors can get 100%, can't they?
Yep, they do.
So let's not lose in this new year sight over, the focus on some of the basic stuff because often that's very powerful for all the allied professions. And we gotta recommit to keep talking to each other so that we can keep things straight. Alan, I think we've covered the list and a few others of the points that we had. I'll just remind everyone that if they can come up with a creative name for what we should call this monthly sort of summary. And I think this is great. I love doing it with you, and we should keep doing it. And we'll keep pulling practical stuff that we're seeing day to day that may be helpful to others.
Beautiful, Marty. I've enjoyed it. I've always enjoyed it. I always learn a lot from you, and we're very lucky to live in a very, very interesting time in a very, very interesting profession.
It is an interesting time. It is an interesting profession. Yes, it is. Wishing everyone well, and thank you for joining us. And Alan, thank you.